page 44 of his evidence in the record, the transcribed record. Page 44, lines 18, line 17 to lines 19. They confirmed that he tested that 4 of those tests spent cartridges, not one has been alleged. It was 4 tests that tested positively to that spent cartridge case. There was also an issue that whether he testified, whether any peer reviews was done. If you look at the transcribed record, Ballistic confirmed that on page 37, lines 12. There's also other pages where in cross-examination where he was requested or tested on that, where he actually confirmed again that there was indeed peer reviews done in respect of the test that he performed. Ballistic's evidence further insofar as the spent cartridge case are concerned, he testified that indeed on page 23, line 16 to line 20, he confirmed that the brick block, also being referred as the ball carrier, was indeed changed of SP2 to affect the results and the outcome of this particular test. On page 61, under cross-examination, lines 10 to 15, Ballistic again confirms that these parts have been indeed changed. The ball carrier, which consists of the firing pin and all these aspects that was already been mentioned by counsel for accused number 2. The ejector, the extractor, and so on, that he confirms that indeed it has been changed. That's why he had to go to the actual chamber. The chamber is where the neck of the firearm and the barrel is actually, it's very difficult to change. That's the one thing in the firearm that you actually need a gunsmith to change that particular part of a firearm. You should be further testified of all the number of firearms that he examined for the ballistic test which he received from the company of accused number 2. That was indeed the only firearm whose ball carrier has been changed. Not 3 has been mentioned, but that was the only one of the ones that he has tested or that was sent to the lab. The issue, I want to address the issue insofar as the viral video is concerned. We have argued this matter meticulously before the video footage was deemed to be admissible. The only issue that the court needed to consider is whether it was indeed relevant, not whether it's authentic or any. The case law is clear in that regard. It needed to be relevant. That was already conceded. The other points that was mentioned by counsel for accused number 2, I am in disagreement with that. The court only need to consider, and the court's got the safeguard of the evidence of Gearhouse insofar as confirming the video footage. I take note of counsel's for accused number 2 argument about the AI and so on. This is not the case in respect of this particular video. As a matter of fact, it's not the contents from what I could see, not the contents, the actual video footage that has actually been disputed. Because they've relied, as I've already previously pointed out, they've relied on the exact video footages from both sides. Not saying, no, this is something wrong, this has been edited here and edited there. There was no such submissions made. And to make it at this point, it's rather pointless. Bishop, the evidence that has been presented before this court is real. The issue regarding Larry Mavuntla that was raised, that we should have sent out a subpoena to a witness that appeared clearly hostile and not wanting to assist the state, was just disingenuous. It would have amounted to a waste of state resources. On this point of Mr. Mavuntla, it is accused number one's evidence that this firearm that was given to him, the toy one, that's as he's alleging, was indeed given by this particular Larry Mavuntla, whom we know the firearm was booked out to on the night in question. The issue is that the distance where the spent cartridge was found in relation where the stage was, Bishop, is neither here or there. Our submission there is whether it was found on the roof or 15, 20 meters from the incident. Remember, these evidence, the stage was reconstructed in the evidence of Becker. So it wasn't an exact science that exactly that is where the stage, but the fact that it was found in such close proximity where the stage was erected originally, Your Worship, this is clear that that firearm was discharged on that night in question. If the court have looked at the timelines, the incident happened at late the Saturday evening, the 28th of July, 2018. We know from the evidence that on the Sunday, which is the 29th, there was no real activity other than Giao's dismantling the stage. The following day, that was the Monday when the cleaners came out, that is when the spent cartridge case was found. The evidence of accused number one in this regard is nobody else had fired shots on the night in question other than himself. So on that basis, that the state is submitting that its case had been proved beyond reasonable doubt. The court was presented with real evidence insofar as the video footage is concerned, the evidence relating to, I've already submitted that this is the best evidence the court would have ever gotten as to what had really transpired on the 28th of July 20. No witness would have been able to describe the incident, the clothing, the singing, the chanting. Who stood where accused number one was in relation to when he fired the shots. I've already submitted that is the best silent witness, the best evidence any court could ask for when it comes to video footage technology. Bishop, there was also a submission made that nobody ran or nobody seemed to. It was clear from that video footage, the moment accused number one firing that shots, the first round of shots, people were running. We counted at least 7 people that were running because accused number one went to the end of that stage to fire those shots in the direction where those 7 people were standing. As a result, they were running. So to submit that nobody did anything at that, it's incorrect. Bishop, I've already submitted that we have gone through the evidence. If accused number one was innocent in any way, I would have made that submission like I did in respect of accused number 2. The evidence was viewed by 2 different prosecutors, as your worship is aware, Advocate Smith as well as myself, and we both came to the same conclusion insofar as the evidence is concerned, and we both have more than 50 years of experience. My job is not to get the conviction at all costs, but to assist the court to come to the correct decision. In this regard, it is clear that accused number one did indeed fire those shots with SPA 249, and that he should be convicted of the charges as it stands. Thank you.
I know you are eager to reply, although there's no provision for that, Advocate Odes and Advocate Matthews, but I will indulge if you so wish, but you say nothing. I see Advocate Odes. I'll give you the opportunity, although
Thank you, Bishop.
part of procedure.
I appreciate it. Thank you, sir. And I appreciate the indulgence, Bishop. I take issue with almost everything that my learned friend has said for the state. And I urge your worship not to be convinced by the manner in which he argues, excuse the pun, with conviction and in the eloquent manner that he put it forward. And I'll make my points very briefly, your worship. He said to your worship, the only firearm of accused 2 of which the bolt carrier was charged. There isn't any evidence, your worship, that accused 2 has any firearms before this honourable court, sir, or even that firearm can be connected to accused 2, and that was the evidence that was undisputed before this honourable court. Your worship, I also take issue with him saying that the only test in relation to videos, whether it's relevant and not authentic, that goes against the Rangoban decision, and to a large extent I'm merely arguing the case for accused 2 as put forward by Mr. Matthews, but I feel compelled to do so because I'm just answering to this. Then the other issue, your worship, was he said that if one has regard to the fact that we say that that the state should have called Larry Mavundla, but he was clearly hostile. He's giving evidence. There's no such testimony. In fact, your worship, I wanted to give your worship the reference, if I may. The captain's statement, your worship, is an exhibit before this honourable court. It's exhibit C. It's also referred to, your worship, at our paragraph 4.7 of our heads of argument. And at Exhibit C, I beg your pardon, Colonel Janssen, not Captain, Colonel Janssen, in his statement at paragraphs 9 and 10 said that Lady Mavunda was fully cooperative. So I don't know on what basis he wants his court to accept that Mr. Mavunda, who was identified as being on the scene and who was alleged to have owned the firearm, was hostile. Because if one has regard, Your Worship, to Exhibit C, and I'll quote it to Your Worship, it's quite clear with respect that Mr. Mavunda was cooperative as per the statement of the very Colonel Janssen, paragraphs 9 and 10. He says there, on the same day after inspecting the main safe, firearm number 6 was presented for inspection, as well as a 9mm P Glock pistol with serial number YYS58 by Mr. Larry Mavundla. The explanation was that the company knew that SAPS were needed for ballistic testing as a result of the alleged discharge of a rifle by Mr. Julius Malema over the weekend of 28 July 2018. And then in 10 he says, the explanation given was, although the firearm was not in East London, on 2018-07-28, the responsible person volunteered this firearm as well as all other firearms in their possession for ballistic testing. So I don't know how one can infer from that that this was a obstinate or difficult witness or uncooperative. In fact, the opposite appears, because he seems to have assisted. Then my learned friend also argued, and now thankfully we're turning closer to accused number 1's case, that it made no difference where the cartridge was found. You only have to ask yourself, Your Worship, as in the tests enunciated in the case that I quoted, the corollary of that. Had the cartridge been found 1.2 meters to the right of where accused number 1 was standing, to his rear, then the state would say, look how it fits in with the trajectory and how easily it ties in. So I absolutely disagree with him, Your Worship. And then he says that according to the witness Becker, the stage was reconstructed. It was quite clear it was never reconstructed, Your Worship. I don't know where he came with that evidence. With respect, Your Worship, that's why I say that one cannot, with respect, accept that. And then he said that the accused number 1 admitted that on the night in question that he was the only one that had fired shots. But that doesn't answer the question, Your Worship, because there's no proof that the cartridge arose on that very night. So it could have been there before, it could have come there after. There isn't even proof that that cartridge was shot. So it could have got there at any time or even been dropped there. There's nothing that ties in with that one fact. And that's why I ask Your Worship to have regard to the cases that we referred to which say that you must take cognizance of all the evidence, not just aspects that suit the state's case. Similarly, Your Worship, and this is the clearest example of my learned friends arguing with conviction, with eloquence, but not fitting with the facts, where he says that if number 1 was innocent, he would have made that submission like he did with accused 2. What did he do, Your Worship? He charged accused 2. When the evidence didn't substantiate it, he then changed his tack and said, well, find him guilty as an accessory after the fact. That's not saying the man's innocent, let him go. And not once did he say that, Your Worship, and that's why I take issue with that statement, and I say that that's totally irrelevant, and it's not even the factor, because it's not the case, it's not borne out by submissions and arguments. Thank you, Your Worship.
I'm happy to say we've reached the conclusion of everything, and now the ball will be in my court, and I'll have the opportunity to speak, but not today. So do we arrange a date in chambers? What do you prefer?
Let's adjourn, Your Worship. Let's adjourn and arrange a date in chambers.
Your Worship, we had set down 3 days. I know it's not attributable to Your Worship, so I'll take no issue. But I have my diary up. Perhaps we can even arrange here, Your Worship. I have no difficulty.
Sorry, I couldn't hear you.
I have my diary here and can arrange a date in open court, Your Worship, rather than arrange it. But I'm in Your Worship's hands.
We would really like to get this matter finished. I don't know whether there's any possibility that we could probably stand down to instead of that.
That's never going to happen, Advocate Matthews. I think yourself, Advocate Odes, Advocate Caesar, you know the amount of work you've put in, the hours, the days, the months. It cannot be done in one day. This court is in session 5 days a week, in excess of 5 to 6 court hours daily, with a turnaround judgment time of every day due. My after-hour times are limited. They are exhausted, including weekends, public holidays. They are fully booked. But once we've reached this point, of course, it becomes due, and I have to spend those hours and days and weekends preparing for this.
January, can I suggest the date 26th
26.
of January?
I don't require so many months. No. Now that it's due, I will put in the work, but it cannot be done in one day. I think you can appreciate that fact. I hear that you would love it to be finalized, but I also need to address many aspects that have been placed on record.
Sorry, I'm talking about the 26th of January next year.
Is it not far?
Sorry, I thought you said January next year.
No.
No. All right, the only other time we'd open is from the 18th of August to the 22nd. Otherwise, then we are really going into next year. I'm the first one to praise regional court magistrates who were sitting with 4 or 5, 6 sometimes murder cases on their roll in a day. Where the High Court has probably got 2 per session.
I've got 187 cases to deal with on my
Exactly. So I really do understand you, and please don't misunderstand. But you must understand that those 186 cases must also be serviced by us, so our time is also taken up.
Of course.
So I'm suggesting from the 18th of August, I don't know whether my letter comes or
Okay. Look, what I'm going to do at this point, since we've encroached on everyone's time and possibly your clients need a water break or a bathroom break, you can discuss dates. You don't have to discuss it with me in chambers. I'll come back to court and you can give me the proposed dates and I can cross-reference in my diary as well. Okay. So can we just agree on what time you would like me to be back?
Put it to 12.
You say it's so convenient. And if I say to you, Advocate Matthews, it's 11:45 now?
It's up.
I see you've got your point. Okay. I've moved offices, so it'll take me between 11:45 and 10 to 12. I'll be back in court. Thank you. Court will adjourn.